Good evening, ladies and gentlemen. Good evening, Lordship, Ladyship, for this online VC meet. Thank you very much. And as we know that due to lockdown, the economy has been brought to an almost complete halt. And on account of MHA order, the state-specific lockdowns, the orders, and the various labor department advisories, which are referred to earlier, trimming headcounts or pay reductions during the lockdown period would be fraught with risk of disputes, scrutiny, and penal actions. In order to understand the nuances of this particular employment laws in the era of COVID-19, we have PHTCCI has crafted this VC meet so as to make the industry leaders understand what are the nuts and bolts of employment laws in the wake of COVID-19. So without any further ado, I would request Dr. D.K. Agarwal, President PhD Chamber, to kindly give the presidential remarks and also welcome the esteemed dignitaries who are there on the VC meet. Thank you very much.
Thank you, Dr. Jatinder. Good afternoon, everyone. At the outset, I would like to welcome guest today, Honorable Justice V.K. Rao, sitting Judge of High Court, as well as Honorable Justice Rekha Pali, again sitting Judge of High Court, Mr. Peter Bartlett, Vice Chairman, Legal Practice, International Bar Association, and of course, Mr. Amir Pasrich, who heads our Law and Justice Committee at PhD Chamber of Commerce, and all the former presidents, members of the Managing Committee, and members of PhD Chamber of Commerce. Well, in a scenario where lockdown is there and it has been extended again up to 3rd of May, the business accepting essential activities has come to a halt. In this scenario, the liquidity position of the businesses, particularly I'll say, because everything has come to a halt. So the liquidity position of businesses has become very, very tight. Even the viability of businesses are getting affected because no work is happening, and even they have to pay for the wages and salaries of the employees. So in such a situation, when there is no liquidity, when there is no work, still somehow the industry has managed to pay the salary of the month of March. However, to pay the salary for the month of April is a big question mark and is the biggest pain area for the industry. Can I request everyone to put their mic on mute? Yeah. So this is the biggest pain area, and we have been getting number of queries, number of questions, and people really want to know, as you rightly said, the nut and bolt of the employment laws. What are their liabilities? So we have collected all the questions, and I have reduced these questions into 3 basic questions, which, because I'm sure that today we have the domain experts and the domain of the, I'll say, fraternity. So I will just make out these questions so that we can get the right answers for these questions. First question is, what is the legality of the various directions, orders issued under the Disaster Management Act 2005 or by state governments under the Epidemic Disease Act 1897 to pay the wages and salaries of the employees? Second, the question faced by the industry is, what is the legal position of employer with respect to the payment of employees who abstain in case of essential activities? As essential activities are allowed, there are employees who are abstaining, who are not coming to duty. So what is the legal position as regard to the payment for the employer? Third question is, what is the liability of employer in non-essential activities for the payment of wages and salaries? And fourth, what is the legal position in all about these 3 scenarios with respect to organizations which are not under Factories Act or under Industry Dispute Act, which are covered under Shops and Establishment Act, where these act applies? That is, what is the scenario with respect to the salaries or the non-workmen which is being paid to them? So as I said, today we have domain experts from the fraternity, and I'm sure we'll have more clarity will have better answer of all these questions. We today have Mr. Peter. As I said, he is the Vice Chairman, Legal Practice, International Bar Association with us. We would like to know from him how they have handled the various challenges as regards to employment laws in his country. So with this, I ask Mr. Peter Bartlett to comment on that. Thank you very much.
Thank you. It's wonderful to join our friends in India from Australia. I think every country in the world is undergoing this extraordinary period. Clearly, lawyers aren't insulated from it, and we're all working remotely in Australia as you are in India. I think Australia is coming through it a little better than a lot of countries, but we do have a lot of businesses that are really suffering. We have a lot of individuals that are really suffering. There are rumours that tonight Virgin Australia, the second largest airline in Australia, will go into administration, and that would be a great tragedy. But going back, it's a great honour for the International Bar Association to join with the Chamber. The Chamber, I've been looking in detail at the website and hearing a lot about it. It's a wonderful organisation. So it's a privilege for the International Bar Association. The IBA is the global voice of the legal profession. We look at the independence of the legal profession, the independence of the judiciary. My section of the IBA is the business-related section. We have over 100 business-related committees in every area of law, some 1,500 of the top lawyers in the world that report to it and work on all of those committees. It's a wonderful organisation. We have the India Working Group, and we look to increase our exposure and activity in India. I was actually in New Delhi earlier this year for the litigation conference, which was a wonderful IBA organised conference. We are very lucky that Amir, who is your chair of your legal committee, is also on the council of the legal practice division of IBA. He's one of the most senior Indian lawyers active in the IBA. I might say he's putting a lot of pressure on the IBA at the present time to try and take our annual conference to India. That would be about 7,500 lawyers and partners going back to see all of our friends in New Delhi, and hopefully that will happen in the next few years. So it's a great privilege for me now to hand over to Amir, and I look forward to the rest of the webinar. Thank you.
Thank you, Peter. I hope I'm audible. It's a great privilege to have you all. Peter Bartlett from Melbourne. It's a long way off and we can hear him clearly. I apologize for the little interruption. It was because he was not audible in between. We are all there. I'm very privileged to have two of the Delhi High Court judges, and I'm going to be handing over to them in a few seconds. I just want to introduce the issues that are arising in this very interesting time of the lockdown. The topic of our session is the law under lockdown, legal consequences of COVID-19 on employment arrangements. We have worked quite hard on this topic because if you asked me about a month ago how much I knew about force majeure, I knew quite a bit about its operation, but I didn't know how it would operate in a pandemic. If you ask me today about the employment law is panning out, I have to say that we are learning every day, and we have a constant stream of new knowledge coming to us as recently as 5 minutes ago. I'm going to stop for a second and say, am I audible?
Yes. Yeah.
Yes, you're audible.
Yes, sir.
So the issues that I'm going to raise before your lordships, and I have to address them as such. It's my privilege to have them here, and I say your lordships. And the questions that arise, we will take up a little later. We've had the opportunity to have the judges of the Delhi High Court very kindly give us 2 keynote speeches, and we will first want to hear them and then see how far we can go with questions. We've got a very small, limited group of people on the Zoom meeting here today for the reason that last time we had far too many and it was uncontrollable, but we have the important questions before us. I think we have to leave it to the judges to also decide what questions they want to ask. So very broadly, what are the issues arising? One is force majeure and its operation on employment contracts. Does an unexpected closure differ from different types of closure under the old employment arrangements? Can an employer lay off employees for 45 days or more? How does that work? What are the rights of the employer in that regard? What are the rights and liabilities of a principal employer who engages labor through contractors? Is COVID-19 a natural calamity? How does it fit within Section 2 KKK of the Industrial Disputes Act, which uses this word? What is the effect of the Ministry of Home Affairs order dated 29th March, which asks you all to carry on paying salaries? What are the implications of orders issued under the Disaster Management Act? And what happens with financial incapacity? Is it to be interpreted as a reasonable cause for not fulfilling those orders? These are all very difficult questions which are beginning to arise. So I have to begin with a caveat. We can't put the judges on the mat and expect them to give the answer to issues that will come up before them in court with a whole series of factual circumstances. What we've asked them to do is to lay out the law so that we as members of the bar can get some guidance from them and then proceed and perhaps also avoid some wasteful litigation. I'm going to take the liberty of introducing Honorable Mr. Justice Rao first. Ordinarily, the duty of us is to introduce the lady judges first, but the protocol in the judiciary is to follow expressly from seniority. And so we've got Justice Rao, and then we'll introduce Justice Rekha Palli. Justice Rao has been awarded the Certificate of Merit from his college days. He's enrolled as an advocate in March 1991. He's practiced in the Supreme Court of India, the Delhi High Court, of course, and that's why we regard him as one of our own. He's been before the Central Administrative Tribunal, Principal Bench, and in various other high courts, also including Port Blair. He has been senior counsel appointed in 2010, and he joined the judiciary and the bench on 17th April 2013. Congratulations, Lordship. I think that was just last week, your anniversary of joining the bench. I'm also going to introduce Honorable Justice Rekha Palli after Justice Rao speaks, but we'll ask Justice Rao to please speak to us first. Thank you so much.
You have to unmute.
Yeah, I have unmute. Yes, I have done that. Thanks very much, everyone. It's a pleasure to be here. First of all, I must thank the organizers for holding this interaction on a very important topic because of the situation which has arisen in view of COVID-19. I won't say 2019. See, the topic for discussion is the legal consequences of COVID-19 on employment arrangement. Now, and we would be talking in the context of India only. And that's what relevant insofar as this topic is concerned. I hope I'm clear, I'm audible.
Yeah,
Yes, yes, sir, very much.
Yes, sir.
Now, to understand this topic, it's very important for us to understand what is the employment scenario in the whole country. Now, the employment in India can broadly be categorized in three types. One is an employment under the central government or the state governments. One is the employment which is under the public sector undertakings, autonomous bodies, and the local bodies. The third is the employment in a private enterprise. These are the three broad categories. Now, when we talk of employment under the central government and the state governments, the employment conditions of those persons are regulated under different rules which have been framed under proviso to Article 309 of the Constitution of India. And they have a statutory force and they will hold the field insofar as those employees are concerned. Now, similarly, insofar as the employees who are working in a public sector undertaking and autonomous bodies or a local bodies under the government, be that a state government or a central government, they are also regulated by the rules and regulations which have been framed by their employers under a particular statute or under the bylaws or under the memorandum of association in a given case, like a company. Now, those rules and regulations have the effect of law, and those would be binding inter se between employers and employees. Now, we have third set of employees who are working in a private enterprise. Now, within the private enterprises, there is a very distinction made between a person who is holding a managerial post or a supervisory post and a person who is holding a post which is below a supervisory level. Now, insofar as those persons who are holding who are working in a position below the supervisory level, we call them as workmen who are governed by the provisions of the Industrial Disputes Act. Now, these provisions of the Industrial Disputes Act are statutory, and those binds the inter se relationship between the employer and employee insofar as those workmen are concerned. But insofar as the persons who are working in the managerial level and the supervisory level, there is a particular pay band also. If you are above that, then you are outside the jurisdiction of a workman. But insofar as those managerial and supervisory people are concerned, their terms of appointment are regulated by what we call it is an appointment letter. Now, what is this appointment letter? Appointment letter encompasses all the terms and conditions which would govern inter se relationship between the employer and employee. Now, this is precisely would be possibly the area which will fall for discussion insofar as this interaction is concerned. That's my belief. Now, Mr. Pashrich, you have asked me the concept of force majeure in employment contracts is concerned. Now, everyone knows what is the concept of force majeure. I do not dilate much on force majeure. It's ultimately an unforeseen circumstance or unforeseen event which may arise, which may result in under a contract. That's basically is the concept of force majeure. Now, there are different events of force majeure that I should not really dilate much. There is a judgment of the Supreme Court which calls out different events of force majeure. One can look at in the latest judgment of 2017 where
We can't hear you, Lordship.
Yeah, Lordship, there is some problem with audio, I
Yeah,
think.
now There's some disturbance, I think, from his side.
Some
I'll just call.
network problem from his side, sir.
Somebody can call him.
just about
You may
to.
check.
Yes.
Yeah.
Lordship, can you log in again?
I think it was disconnected.
Yeah, now it's okay.
Yeah, now we can hear you.
One,
Now it is okay.
That's fine, sir.
1 minute, Mr. Pashrich.
We can hear you now.
You can hear me?
Yes.
Where I don't think video is so important.
I know. No, it's fine, sir. It's fine. Please go ahead, sir.
You can even switch off the video because then the audio would be very fine.
Hmm.
He can switch off the video. You can tell him, Amir. If he switches off the video, he'll be able to hear the audio.
Now, insofar as India is concerned,
Lordship, can you switch off your video, please?
Then the audio quality would be better.
Exactly.
in the contract
Yes.
of force majeure, the employer, and possibly he can't invoke that concept of force majeure and suspend the contract because of certain natural calamity. So what it presupposes is the clause regarding force majeure must necessarily be in the contract for an employer to invoke the clause and suspend the terms of contract till such time the natural calamity continues. That's basically is the position of law. Now, I have already told you what are the different events of the force majeure. Now, what is the effect of a stipulation of force majeure not being in the contract? I've said he can't invoke it. Now, is it the end of it that if a natural calamity has arisen, that the employer cannot discharge or cannot suspend, cannot delay the obligations under the contract? The answer would be no. In a given case, an employer can invoke the concept of frustration of contract, which we call it under 56 of the Indian Contract Act. Even assuming for a moment there is no clause of force majeure in the contract. Hello? Hello?
Yeah, we can hear you.
Even if there is no stipulation of force majeure in the contract, if a situation arises because of a natural calamity, a contract is impossible to be performed, possibly an employer can invoke the concept of frustration of contract. That is, it is impossible to continue the contract or the contract of employment with an employee. But surely a caveat, surely the case must fall where an employer cannot, or where the contract is impossible to be performed by the employer. That's very important insofar as while invoking the concept of frustration of contract. Now, a question may be asked, what is the difference between a force majeure stipulation and a frustration of contract? In a force majeure stipulation, the unforeseen event is stipulated in the contract because of which the contract can be suspended. But in a case of a frustration, it is a case which is outside the contract. That means even if there is no force majeure clause, you can still invoke the frustration clause under 56 and say that it is impossible to continue the contract for time being till such time the natural calamity continues. And if we suspend the contract, whatever are the obligations on the contract he can escape those liabilities under the contract. That's basically is the position of law. Now, insofar as this is talking about the employment between the employment conditions of a manager or a supervisory level officer with the employer. Now, we have set of employees who are workmen who are working below the level of the supervisory level, who I have just called that they are treated as workmen under the provisions of the Industrial Disputes Act. Now, insofar as these people are concerned, their terms and conditions of employment are strictly regulated by the various labor enactments which have been enacted by the Government of India. And those would be applicable to them across the board, and they are statutory in nature. So this is what is the basic scenario insofar as the employment, various types of employment in this country is concerned. Now, I would, given this background, I would welcome any of the questions which the panelist wants to ask you for me to reply. I think before that, I would appreciate that if Ms. Palli can also throw light insofar as what are the rights and liabilities under the different labor enactments in the country.
Amir, you have to unmute. You have to unmute. Amir, you have to unmute. Kindly unmute.
Yeah, Mr. Amir, you have to unmute.
I've unmuted.
Yes,
I've
done.
unmuted. I've unmuted.
Yeah.
It takes us a
thanks.
second. Good afternoon.
Yes.
Firstly, thank you for that, for setting that out very clearly, and thank you for taking questions later on. Justice Rao, that was very clear and understandable. And also the operation of Section 56 of the Indian Contract Act on employment contracts is something to be seen. I'm going to.
Surely.
Can you hear me?
Yeah, I can hear you.
Yeah, we can.
I'm going to introduce Honorable Justice Rekha Palli, who is a judge of the Honorable Delhi High Court. She's a product of Lady Irwin School, and she graduated from with science, which is one of my weaknesses also, from Hindu College. And she has a law degree from Campus Law Center in Delhi. And after that, we have Honorable Justice Palli is somewhat senior to me, having commenced law practice in the late 80s in the Punjab and Haryana High Court. And then she's registered in the Supreme Court, having practiced in the Delhi High Court, the Supreme Court, and various judicial fora, including the CAT, which is a hotbed of learning for us all in terms of labor matters. Justice Palli has joined the bench of the Delhi High Court on 15th May 2017. And before that, she was designated as a senior counsel by the Delhi High Court in 2015. Honorable Justice Palli, thank you so much for taking the time off and for speaking to us on this extremely important topic. Thank you for being with us.
A very good evening. Can you hear me?
Yes, we can hear you, ma'am.
All right. A very good evening to all of you. And thank you for a very, very generous introduction. You really actually, made me remember what all I have done.
You've done a lot.
After the very enlightening, insight given by Justice Rao about on the aspect of force majeure and its effect. Now, I would want to discuss the rights and liabilities of employers during this lockdown. As we all know, COVID-19, which we have barely known for more than about 3 months, has raised a global crisis, which has earned the infamy of being the worst crisis after the Second World War. Its highly infectious nature has now led to global lockdowns, and meaning thereby that shutters on all workplaces, most workplaces across the world are down, affecting about 80% of the workforce. I will refer to this when I come later. Affecting now the governments all across the globe. As just though I'm going to concentrate on the legal position in India, but I want to highlight that the governments all across the globe are working on it. They are trying to find out what is going to be the effect of this global lockdown leading to unemployment on the economies, and are trying to innovate ways how to deal with the situation. Now, as you know, once workplaces have closed, there is no business. There is no business. And now, today, unemployment has become our second most concern. Today, everybody sitting at home is talking only of health. And the second thing which we are all talking of is unemployment and the liability, whether the employers with no business is being generated, no revenues there, whether they how they are going to survive. This is the challenges are there not only for the employer but also for the employees. Both sides are saying. On one hand, the employers are saying they are not able to generate revenues. Employees are on the other hand saying that we have worked for them. Where do we go? The country is looking at a situation where the employees cannot also be left without any source of even source to of income to run their families, to pay the rent. So before I go into that, the first aspect is, as Justice Rao also pointed out, there are statutory obligations. There are statutory obligations under the Payment of Wages Act, Industrial Disputes Act, Contract Labor Act, and a lot of other acts which I don't want to go on at this stage. But these, by and large, these provisions are applicable when the employment is there, when people are working. So if you would look at those provisions in a stricto sense, they would have probably not been really applicable. When no work is being done, the employer cannot be faulted for not being able to work. That is where the government stepped in, like other and stepped in and has issued notifications and orders making a little departure from what would be the normal position. As you would understand, in a normal situation, if work was not being done, or if the factory was closed because of an order of the government, probably the employer would have a justification, which today a lot of employers are feeling not to pay. Here is the issue, the crux of, in fact, what I personally feel is that the crux of the issue lies in these orders and notifications being issued by the MHA and the Labor Ministry. It is these orders which are actually are the talking point and are creating problem both for the employer and the employee to think. Here they both. So I am going to now, before I go take you to the aspect as to what will be their real rights, let us at least have a quick look at the three important orders. The first order, as you know, once COVID set in, the first order was issued, relevant order was issued by the Ministry of Labor Affairs, Ministry of Labor on 20th March. This order, a lot of people would say it is an advisory. Dr. Jatinder Singh, can we have this advisory on the screen so that people can just have a look at it? 20th March advisory. Is it possible for you to have
I
it?
have it. I have it. I'll just put it on. 1 second.
If it is, otherwise I will.
Just 1 second.
Have this advisory by the MHA on 29th March.
No, I wanted the advisory of 20th March first. That's the labor.
Yes, I'll just get it.
Because the starting point is that advisory.
Yes, I have it. Just 1 second.
All right, but
Share screen.
because I would want. Yes.
Can you see it now? It's
No, it's again on the 29th. All right.
yes. This is what your ladyship wanted. If you just see.
No, I don't want. Yes, it's there in there, right? No, it's not there. Anyway, it doesn't matter. I'll proceed on my own. It's not there. See, let's come back to the. As I said, it is these orders and advisories which is the talking point today. Which is, in fact, it is because of these orders that the employers are worried, and the employees are also concerned. Now, as I said, the first order was issued by the Ministry of Labor, Ministry of Labor and Employment. This order, then I'll have to read that order. This order said all employees of public, please, and private establishments may be advised to extend their coordination by not terminating their employees. The word used here is employees. And then it goes on to specify particularly casual or contractual workers from jobs or reduce their wages. Till here, the advisory ends. The next line says, if any worker takes leave, he should be deemed to be on duty. I'm putting a little emphasis on the word he should be deemed to be on duty
Yes.
without any consequential reduction in wages for the period. Then the next line which is relevant is further, if the place of employment, yes, now we've got it.
Yeah.
The place, now if you'll see the second line of the second para, further, if the place of employment is to be made non-operational due to COVID-19, the employees of such unit will be deemed to be on duty. I will refer to this a little later, but this was the starting point. It is being read as an advisory. The first part advises employers not to terminate their employees, and it doesn't say only workers or workmen. And the second part gives the deeming provision that they will be deemed to be in service. Now, since this order was not really under any statute, it doesn't really talk of any statutory power. This was followed by a notification by the Ministry of Home Affairs now, which on 29th March actually set the ball rolling. Can you come to that, please? Can we have the 29th March now?
Yes, just a second.
Yeah, it's there.
Has it come?
Yeah, it has come.
This is the one you showed to me, right?
Yeah, it has come.
I can't see it, but anyway. Yes, it's come. Now, will you please come to the para below? Yes, you'll have to come to the para 3, Roman 3. Have you got it? Yeah. Roman 3 of this. All employers be in the industry or in the shops and establishment, commercial establishment, shall make payments of their workers at their workplaces on the due date without any deduction. Now, it is this order or notification which actually has been issued under in exercise of Section 10, power under Section 10 of the Disaster Management Act, which actually vests the central government, the National Executive Committee, of which the Honorable Home Secretary is the chairperson, to take such measures. Now, if once this order has been issued, it is this order which as on date is binding on everybody. I remember Dr. Agarwal pointing out a question. I will answer that after I just run through the issues which I wanted to highlight. Because he asked me, the first question he put was that whether this is a binding, what is the legality? That's one of the questions, Dr. Agarwal, you asked.
Yes, ma'am.
Now, come to this. Now, when you see this is an act, this is an order passed under Section 10, which means it is a statutory order. It is an order which is not really a simple advisory or anything. And what most importantly you all have to understand is that by virtue of Section 72 of the Disaster Management Act, all these orders, even if they are inconsistent with any law, if they pass any regulation or any orders passed, they have an overriding effect. So even if you have the Industrial Disputes Act saying something, as long as the lockdown is continuing, this order is holding the field. And this, obviously, as all of you probably by now know, Section 51 of this provides for penal consequences if you are not able to show any reasonable cause for not complying with it.
Yes.
So what I would say is that, yes, sorry, you wanted to say something?
I just wanted to say what constitutes reasonable cause, Your Ladyship.
I'm going to come to that. That's what I'm coming to. That when I come to
Sorry to interrupt.
I'm just trying to give you a broader
I'll
picture.
put myself on mute.
Yes. All right. Now, yes, it says whoever without a reasonable cause. So this is a penal act. It's a very serious section in the sense that it can not only lead to suits against a person violating, but even they can be prosecuted under Section 51. Obviously, the defense is there for reasonable cause. We come to that when I come to the second act. Now, this order of the MHA has been followed by state government passing Simic Diseases Act. In fact, if I'm not wrong, recently the state of UP issued an order directing registration of FIRs of against people who have not paid wages to the workmen. Now, before I order on this, and the clarification given by MCA. In fact, MCA has given a clarification on 10th of April, which some newspaper reports and articles across the social media are kind of interpreting it to say that now the effect of the notification by MHA has been nullified, and it is not mandatory for employers to pay wages to their workers or employees during the lockdown. I'm sorry to say that that is something, that is a manner in which I don't know how it's being interpreted. Firstly, the Ministry of Corporate Affairs had no jurisdiction. It has only given its views that this is not going to be counted as a CSR. It is a statutory or a contractual obligation. The mere use of the word moral obligation, that even I would say, even if it's a contractual obligation, statutory, it is also your moral obligation today. That's the way it has been used. So I would not say as long as the notification of MHA of 29th March, which stands today you can't say that because of the clarification issued by the Company Affairs that it is not no longer mandatory. Now coming to the core question, all employers and employees are very eager to know what should they do, and what is, after knowing that this is the notification. See, now in these, as Justice Rao also said and Mr. Pasrich also said, every case will ultimately have to be decided on case-to-case basis. Reasonable cause, if Section 50, firstly, the issue would be, now before, there are three kinds of employees which we have to understand. One is your regular employees, which will include your as Justice Rao has explained, the managerial level, supervisory level employees, and the other is the workers or the workmen. But the second would be your contractual employees, where you have a contract for say for a particular period. You suppose you enter into a contract for 6 months or 1 year, and it is expiring during the lockdown period. The third will be your outsourced employees, and lastly, I would say to some extent the daily wages. Now, as far as the regular employees are concerned, my view would be that irrespective, as long as the notification is holding and the advisories are there, whether you can say that it will apply only to workmen who are covered by the Industrial Disputes Act is a question which will actually need to be decided by the courts ultimately. Today, the first advisory very clearly made it evident that it was applicable also to employees. When I read out that advisory, I explained it to you. I tried to put my point that it is using the word both employee and worker. So it can't really be said. So as far as regular employees are concerned, I really don't see how the employers, irrespective of their financial conditions, can really say that they are not liable to pay. We have to all understand that this COVID-19 is a very extraordinary situation. We are dealing with a world, is a problem, unprecedented situation. The employers may be really feeling bad on saying that we are not in a position to pay, we don't have the funds. But you cannot lose sight of the social problem it has created. So saying that our regular employees we will not pay or we are not liable to pay is something which will be devotes the notification as long as the notification stands. Now coming to your contractual employees. Contractual employees, obviously, if the period is getting over, you will be liable. You are entitled to terminate them and not extend the contract after the period of the contract is over. And there, your Section 32 and 56 will also come into play. If they are employees where there is a clause, or you can take those. Those are your contract where there is a specific contract. Now coming to the outsource, which is another question of real importance today, because a lot of our industries are using, especially I can see Mr. Chawla sitting there. He is appearing for a lot of security guards. They are mainly outsourced everywhere. So when we talk of outsource, the question would be, it will not be just simply, this is the case as Section 21, 22 or we all know of the Contract, Labor and Prohibit Acts, clearly states that if the contractor doesn't pay, it's the principal employer's responsibility. In such cases, during the period of lockdown, at least I'm repeating, during the period of lockdown, the principal employer, even if he has outsourced, especially because the advisory and the MHA order clearly says whatever kind of worker it is, the employer will remain liable to share the burden. In such circumstances, the best part would be to have a conversation with your contractor and see how both of you can get out of this problem. That is the only way they can get out of it. There has to be a conversation between the two. It's not as if the contractor is not liable, and only because the principal employer is liable, you have to understand that the advisory and the notification are applicable equally to the contractor, because ultimately they are his employees. As principal employer, even if you had outsourced them, your liability is there. But it's not as if the contractor is going to get away with not having to pay. Now you come to the daily wages. Now, daily wages, or the question will be whether they are liable to be paid will be again on case to case. It will depend on the length of service they have put, and another very relevant, whether they have abundant service. See, as we are aware, the moment the lockdown was introduced, a lot of the daily wages have themselves gone away. That's the complaint coming from employers, and this will be in response to another question put by Dr. Agarwal regarding workers who have gone away in respect of essential services. So those are mostly daily wages. Regular employees, I am not too sure how many of them have gone away, because their regular employees are sure that they will get their salaries. Now we come to the question of part payments. A question was put. There is a question whether payment can be made in partly keep or 50%, 60%, or the employers have any leeway in that. There also, I would like to say that Payment of Wages Act or the Industrial Disputes Act does not provide for any part payment. In fact, the advisory of the government clearly says, irrespective of whether there is a lockdown and whether they have worked, whether the establishment is closed, they have to be paid their full wages without any deduction. So you can't really say that there is any provision for payment of wages. Now I'll come to the question of adjudication in courts. See, that's a very, very relevant question, because the topic, because that is what is concerning today all of you. I think the advisories and the notifications, all of you. I can hear somebody wanting to say something.
Kindly put everybody on mute.
It's by accident, leadership. Please go ahead.
No, it's all right. I thought maybe you wanted to ask something.
No, somebody just got in by accident.
All right. See, now when we come now that I've taken you through the notification and the provisions, what I want to say is that these notification and the competing claims of the employers and employees, especially in the light of the employers claiming that they are willing, even some of the employers coming and saying that we are willing to go to jail, but we can't implement these orders. These will therefore need to be interpreted by the courts. It will open a wide range of questions, not only in civil suits. It can lead to claims before the disputes in the labor courts, complaints under the Disaster Management Act, where all of these will be interpreted. Recently, I was dealing, while hearing a matter through video conferencing, I was dealing with a writ petition where employees of a hospital came in complaining that we have been terminated on 30th March 2020 because on the ground that a sub branch of the hospital has been closed. So these issues will keep coming before the courts. And as you are aware, a petition has already been filed in the Supreme Court challenging the validity of the notification which we are talking about. We don't know what is going to be the result of that. So probably, I think, Dr. Agarwal, you get the answer. I will not want to answer, because today, and there is another petition filed by some journalists, a group of journalists, saying that that the media is laying off people on the ground that the circulation has reduced. So these issues, as I said, today the situation is very dynamic. All the governments are trying to do their bit, even as we speak. You don't know what the central government is doing. The state governments are. I recently read in one of the state, the chief minister of Punjab saying that this notification should be reconsidered, keeping in view the problems being faced. So we don't know. Our government is that. So the courts will ultimately have to balance. Today, prima facie, what appears is the employees have to be paid, especially the regular ones. It's only on the different aspects where you see, where you feel that they have gone away. Now we'll come to, before I come to the question, now our government has also taken some initiatives. Unfortunately, keeping in, though we hear of governments like in countries like UK, and Peter, I think informed me
Australia.
yesterday that even Australia, Denmark, and a lot of other countries, the government is paying subsidy to the employers, which we are not, which our government is not in a position to pay because of the look at the population. But still, it is trying to take steps. We are trying. The EPF has been kind of EPF 24%. I think 3 months the government is going to pay, and some amount is going to the daily wages through various schemes which have been introduced. That amount, even if you are tomorrow held liable to pay to those daily wages for during the period of lockdown, that amount obviously will be counted for. The courts are not going to just say, all right, you are the employer, you will pay his wages, whether he gets an amount from somewhere else or not. That's not the way it works. So you will have to consider this aspect also. Now the employer's responsibility and availability of leave. There was another very interesting question being raised by somebody, that what if we treat this period as leave period, like an employer. That again, I'm sorry to say it can't be read, because once the question of leave would be when you take it on your own, when you are being asked with an advisory that they will be deemed to be in service. I don't know, unless by consent, as we read in the papers, I think in the aviation ministry, maybe Vistara, I think some of the senior officers have agreed to treat some of this period as leave period. In fact, the High Court is also doing it to some extent. We're willing, we have said we'll work in June. So there, by consent that takes place, it's a different thing. But saying the employer's question that this be treated as leave period, I'm sorry, it can't be, because the notification is very clear, and the advisory is clear that they have to be deemed in service. Now, the last question of the layoff. As Mr. Pasrich, you had said in the beginning, question of layoff of 2 triple K, the powers under layoff when you can't give them work. The pro, at the outset only I said the statutory obligations were different under the normal Payment of Wages Act industrial dispute. In view of this circular and the notification, I don't really know whether in this lockdown period you can treat them as being layoff. After this, yes, after the lockdown period is over, maybe some industries will have, or establishments will have to resort to layoff. That will depend from case to case basis. My request to all of us would be, I am not talking only as a member of the legal community or the bench. I am saying as a person, of a member of the society, that we all have to stay together and see that our economies revive. If we start indulging in layoff rampantly, what is going to happen is those people will have no money. The demand supply will again come to an end. It will actually worsen the cycle. We all have to have some endurance. Maybe, as I said, it is not just because you can't pay. Your employees are your employees. You can talk to them. They can be made to understand. And you will not just be penalized like that. That Section 51 will not. You can show reasonable cause, but we all have to stay strong and hope that we will come out of it. I think now I'll be open for questions, whoever, and I will also, after Justice Rao answers the questions, I'll come and try and answer in my own way the questions posed by Dr. Agarwal. Thank you. And
Thank you.
Thank you so much. That was very enlightening. I think it answers many of the questions which people have put, some of them impliedly, some of them expressly. You have to read between the lines in what Justice Palli said and what Justice Rao said. Also, you have to understand the perspective that the judges are taking. And I will only ask the people who ask questions, when I'll be putting them after a little while, to be short and ask a very short question. The judges, of course, can say what they don't want to answer, and they can throw it back to people like me. As far as
yeah, we have Mr. Sanjay
Mr.
Bhatia.
Pradeep Musani.
Yeah.
Just a minute, Dr. Chitinder. So I wanted to say a little bit about this whole issue of COVID-19 closure. From what we've understood, and very clearly so, is this is a force majeure situation. So there's no dispute, it is force majeure. It is a natural calamity, it is an epidemic, it satisfies a lot of criteria of statutes which actually cover these issues. You need to see those statutes, you'll find words used in the Industrial Disputes Act, which is quite an old statute going back and talks about natural calamity or any other connected reason. You'll find lockout also talks about suspension of work. And there will be times, and your ladyship, I'm not daring to disagree with the bench because we have to follow the lead from the courts. But for private practitioners, one of the big things is going to be trying to convince the judges that the Ministry of Home Affairs does not dictate the terms of a contract. And an employment is a contract. It is a matter of mutuality. It is imposed with various labor statutes, such as the Payment of Wages Act, the Industrial Disputes Act. And as we go through these very difficult cases that are going to come before us now, we will be fighting for the question of whether we can create a Chinese wall that is a total silo between the Ministry of Home Affairs and the employment legislation. So from what I've understood from your ladyship, the answer is no. If we are going to take the terms of a contract and impose in it an extra provision which says, in effect, that you have to pay wages during COVID-19 and the lockdown, I don't think it's a problem if it lasts till the 3rd of May. But the real difficulty is if it lasts till the end of August, because then you have bankruptcies coming in, then you have companies not being able to pay beyond, already today is the anniversary, I think, or maybe tomorrow, day after, of having been out of work for a month. So how long can this continue? And if the Ministry of Home Affairs order issued under the disaster management guidelines, one of the biggest questions which came up, of course, is gone to the Supreme Court, is the legality of that order. So we're going to trouble your lordships a lot. We're going to ask you from time to time as to where is this line to be drawn between our contract, between the concept of employment law, and also what happens when the lockdown opens. For example, we are told that 30% employees can be taken back and 70% will have to sit at home. So can a government, and does a government have the power to tell us to pay those 70% while they sit at home? That question is not yet open, but it's going to come up. Is this a question for which insurance from the ESI with 84,000 crores has to impose itself here? Does the ESI come in? And I think about 10 minutes before this session, there was a circular of the ESI also, which is being put out. And when we have a series of decisions going to hit us, where everything is in paralysis, how would the ordinary litigant treat this? For example, if you consider, I'm sorry to put it in those words, but an ordinary laborer comes and says, okay, I haven't been paid half my wages because unki marzi thi. Then does he have to file a civil suit to recover those half wages? Does he file an industrial dispute, which takes 10 years to recover, put it in simple terms, 7,000, 10,000? And there are employers where you have 20 employees only, and those are the ones who are most affected. So they will try to take every shortcut. There's an opinion that was shared with us from FICCI as recently as about 3-4 days ago, which my clients have brought to my attention and they're relying upon, where they are saying that, no, this is not mandatory. This is, it is a moral obligation.
Advisory. It's advisory.
So this debate will continue, and the people most affected will say, will see, we would rather not pay now, wait till it goes to court, let the suits, industrial disputes come up, and then when our factories start turning again, then we will find the money to satisfy these debts, including debts towards the employee. So this is a change which I see. And just to end this, my little lecture, I apologize, but I was also classified as a speaker, so I have to put this up. You know, we have the question of layoff and lockout. Layoff, in the ordinary terms of the Supreme Court, going back to the Imperial Hotel case of 1959, it says that without an employment condition, you cannot lay off. Fine. Now, we are in a state where the word ordinarily is also used there. And if we take that to its logical conclusion, we are not in an ordinary state today. The statute allows layoff. The statute also recognizes lockout and closure as something that triggers lockout. So what I'm suggesting to your ladyship and to your lordship Justice Rao is, we are in a state where lawyers will, and that's our duty, that's what we do for a living, we will create the controversies to bring them to the court. We will ask your lordships to balance between two different statutes. And then we will ask your lordships to explain how a Ministry of Home Affairs can step into your court and say, this is mandatory now, especially for someone who says, I simply cannot pay. One of my clients has told me, I'm going to jail. I will go to jail because I have 2,000 people on the road and I cannot pay them. So I'll go to jail. They can all sue me then. So that's my end of my little lecture. I'll put it to questions. Would you?
Before you begin, see what you've just said. As I started, I said, as the notification stands today, you are right. That's what you do for a living, and you will challenge it. It's already been. I refrained myself from commenting on the legality of that for this reason. This is not the platform where we are going to discuss on that.
Right.
So if the notification stands, yes, whatever you said, obviously this is the question which the court will have to decide. If the notification is set aside, obviously, then you go back to the statute. There you have different conditions altogether. In fact, the notification was issued for this very reason. And
Yes.
one more question which you just said, that whether they will go to suit or a labor court, the issue will be the Disaster Management Act also provides for prosecution. Don't forget that. That's all. Now you will open the...
And Amir, before you allow anybody to ask question, make sure only question related to employment are asked. No other questions.
Yes, there are some questions that have come to us about leases and rent. I think if you want, you can call me independently, but we looked after those in the previous session. So we'll focus on employment law, and I will ask
Pradeep Multani ji. You ask Pradeep Multani ji to speak.
Mr. Multani, please go ahead.
Good evening, Your Excellencies. My question is again with regard to the ESIC. We all have been contributing to ESIC on the ground that if an employee falls sick, then the payment will be done by ESIC. Right. Today, they have got 84,000 crores. And today, when the labor is not coming, they are basically, okay, there may be a lockdown, but they are not coming because they are scared that they will catch COVID-19 and they'll fall sick. And if they die, they'll have problems with the family. So why should ESIC be not held liable, especially when they have a corpus like 84,000 crores lying there? This is question one. Your Excellency, the second question is, the government says that essential services like pharmaceuticals, Ayush, food industry has to function and do even overtime so that there's no shortage of any of the medicines and things like that. Now, what is happening at the ground level is the union leaders are instigating the labor, telling them, go home, you will get your wages anyway. Now, when your factory is open, you are telling your workers that please come to work, and they are telling you that look, whether we work or not, we will be paid, or because the present people are working, if you don't work, you'll pay us, but now if we come to work, pay us double the wages. Now, what will be the consequences for these people whom we do not pay wages in essential services who are not willing to work? Thank you, Excellencies.
I would like to add a corollary to what my colleague Mr. Multani has said. The corollary is that there are, for the lockdown is partially being eased, and from tomorrow onwards or today onwards, many of the factories are going to run at 30, 40, 50% capacity. So those, how does a company choose which people are allowed to come, which are not? And those who don't come, those who are asked to come, they will say that the other person is getting paid without doing any work. Exactly the same problem as in the essential goods industry. So I think this is an issue which needs a very serious addressal.
So Mr.
Your Lordship.
Sanjay Agarwal is our Senior Vice President and Mr. Pradeep Multani is the Vice President of PhD Chamber of Commerce.
All right. Yes, Justice Rao would.
We have a question from Mr. Sanjay Bhatia also.
Let's answer one by one. I think we should. Justice Rao, would you like to answer or you want me to answer? Let's have, yes, Mr. Pasreej, you'll have to, I'm not able to.
I leave it to both of your lordships. I dare not interfere.
No.
We'll put the
I think you can
questions to-
start that, yeah.
Because I don't want to go on collecting questions and then it's better to answer.
I think your lordships can answer these questions first, then we'll continue. We've got
All right.
some more.
See, Mr. Multani, as you said about that ESIC, Mr. Pasri just mentioned that about 10 minutes ago, some order has come from ESIC. I don't know what that is. The question, you may have a very valid point, Mr. Multani, that if the ESIC has a huge accumulation, which you say, as I said in my address, that a lot of the governments are giving subsidies to the employers. You can, this issue, probably this is not the forum, but yes, this issue can be taken forward, that if the government is not in a position, keeping in view the population, the ESIC where you have all been contributing, if it has the fund, it should look into this. Somebody will have to apply the correct forum, but your question is probably a very valid question to be addressed at some other place. Now I'll come to the question the second question which you said, that if essential services are working and the employees or the workers choose very conveniently not to come, there obviously, Mr. Multani, if your employees are themselves choosing not to come, it will be a case of abandonment, and there you may have a defense. You may have a defense that we will not pay them unless it is shown that that employee was under some treatment or was under unwell or was quarantined. In normal cases, yes, it can't be said that an employee, despite being given the opportunity to work, in a way, it will be said that there is no lockdown in your premises. If your establishment is open and he chooses not to come, the courts will obviously try and interpret it by seeing whether it's an abandonment of service. And Dr. Agarwal and Mr. Agarwal, your question about saying that partially opening which to come, I think the government, there will be a way where you as an employer can rotate those people. Maybe for 2 weeks you have another 3 weeks, so that it will be giving them resting period also. And there'll be no heartburn also that we are being made to work and paid. I think these are modalities which evolve, which the industry will have to evolve itself.
In that case, you will have to pay the full amount to all the employees.
Unless you will have to, but only to your that's what I said. There are different kind of employees, contractual, daily wages. You will have to deal. These are questions which will evolve with time. Today, but the problem was what? Yes, please. Yes, Mr. Pasreej, your next question.
Yes, I just wanted to say the ESI order has come. Employees insured under ESI who are not able to attend the workplace should be treated as sick as they are not able to attend the workplace due to order from GOI to protect the health of those insured persons. Hence, ESIC should extend the benefit of sickness, that is 70% of the average daily wage for the insured person for the lockdown period.
There you get your answer. That's what I said.
So there is
excellent.
come from the government just now.
So my view
That's a very good order.
That's what I said. My view was already there.
Yes, it was very well.
You mentioned this.
But at least
This
they
is
did
what
it.
exactly you mentioned, yeah.
Yeah, but I think the next question related to this is again would be Provident Fund, because when we are paying workers or employees for the period in which they have not worked, we will still be incurring the liability for provident fund on top of the actual wages paid. Now, this is something which would be a punitive measure against the employers and even for the employee, because even in this time he is having his net take home deducted. So, would your lordships have any view on that?
Justice Rao? Where is Justice Rao? I can't see him.
Justice Rao's mic is off. Sir, if you would please unmute your mic.
Yeah, unmute him. Yeah.
Justice Rao, please unmute your mic, sir.
Yeah. Hello, now I'm audible.
Yes,
Yes,
you are.
Yes,
we
sir.
can see you also.
I'll just go back what Mr. Multani had asked. Multani has asked the questions. See, there are only two things. One thing, insofar as the contribution by an employer is concerned, that must be kept in mind. There is a legal obligation under the contract. Before 21st of every month, you have to contribute it. It's a different question that ESI has an amount of rupees 84,000 crores deposited with them. But that not be a reason for you to escape the liability under the ESI Act. That's first. The second question which Mr. Multani had asked was regarding, being essential services, the employees are not coming. During COVID, the employer was not in a position to give work to an employee, and the employee was not in a position to take the work because of the lockdown position. Now, after the relaxation has been given, and there are certain essential services where the employee must come in, and you are offering the employee an employment if he is not coming, what Justice Palli has said is the appropriate action. Now, third, what Mr. Agarwal has asked. That's right, Mr. Agarwal. I think I agree with Justice Palli. The appropriate would be to make a roster so that everyone gets employment and there is no hard burning. 15 days, 15 days, 15 days, or 10 days, 10 days, 10 days. Everyone is getting employment. There is no hard burning. Now, what was the other question which has been asked?
The other question was regarding provident fund.
EPF contribution.
Yes.
Mr. Agarwal, the position is simple. The relationship between employer and employee doesn't cease to exist. It's continuing. Your liability under the EPF Act must continue. You can't say that the gentleman, he's not coming, he's not entitled to pay wages. I'm not entitled to pay wages. I will not make EPF contribution. That cannot be called for, to be very frank. But that's the position of law. A statutory liability must be adhered to.
True.
Yes.
Here, Justice Rao, I think there is a government order also that they will take care of employees 3 months provident fund dues where they are not working and the salary is less than 15,000. So to some extent, the government is taking care of this.
That's right. Yes.
We have one big question which has come from the past. Your ladyship did address it.
Mr. Sanjay, you can allow.
Just a second. So there's a question that came to us.
You can allow, ask Mr. Sanjay Bhatia. Yeah, please.
Just a second, please. There's a question that came to us online, which is that whether consent and an agreement with the employees or with the union can override the order of the Ministry of Home Affairs. And you see, many employers are facing the difficulty of not being able to pay. So if they arrive at some kind of arrangement with the employees, does that override the MHA order?
Yes.
Would you like to take that?
Yeah. You want to answer or shall I answer? Very well.
No, I would like your lordship's answer.
Very well. Mr. Pashrich, the very first question, the important issue is insofar the legality of the order. To be very frank, given our situation, surely we would not be in a position to answer, and Justice Palli has just rightly said that insofar the legality of the order of the Ministry of Home Affairs is concerned, that it's so you, the lawyers, who have to find an answer for yourself, not us. That's one. Now, surely an order has been issued under Section 10. Firstly, no employee would agree for such a deviation from what benefit he is getting under the particular order. And if there is a directive from the government of India, I don't think any employee would say that I don't want wages. I don't think he would agree for such a situation. if any such a situation has arisen, I don't know. He may ultimately go to a court and see, look here, that this has been done under coercion and by the employer. Have been made to sign this kind of a documents. And if he goes to a court, surely he will have the outcome is very well known. No, surely such a plea would be accepted of an employee.
But I think your lordship has answered the question. Thank you, because this is actually happening. So I think that's an answer.
No, that's what it is for the employer to take his chance.
Yeah, of course, of course. Let me put a question. I think I have Mr. Gulshan Chawla on the.
Yeah.
I'm going to ask him to ask a question which he had ready for your lordship's 1 second.
You have to unmute Mr. Chawla.
I'm just going to do it. Yes.
Good evening, Your Lordship, Justice V.K. Rao, Justice Rekha Palli. It was such an insightful session. We never had whatever the doubts we had till now. All those doubts are cleared. Now we can give better opinion to our clients than what we have been giving till now. Now,
Chawla, I'm sorry to interrupt you. We are only narrating what is the position of law, which you know, which Mr. Pashreech knows. There is nothing different we are saying.
Thank you very much, sir. Now, there is a very small question which we were thinking if we could put this question to you, sir. What is the effect if an employer treating COVID-19 situation as a lockout? Because lockout also talks about suspension of work. Can an employer do it? Take this COVID-19 situation as lockout, sir?
So your question is directed to Justice Palli or Justice Rao?
It is directed to both honorable judges.
Justice Palli would like to take it.
All right, I'll take it. See, your question, in fact, is answered in the notification by MHA. If it says it's non-operational, he will be deemed to be on duty. That's what I said I started, that this notification, that lawyers will find ways under the Industrial Disputes Act, that once it says whether it is non-operational for A, B, C reason, he will be deemed to be in service, means deemed. That's it.
Thank you. Thank you.
This is Rao wants to add something.
Thank you. And just adding to Justice, my Lord Justice Rekha Palli said that whether the workman can go or the employee can go, the notification dated 20, the noti. Am I audible?
Yes,
yes.
Yeah, just adding to what Justice Rekha Palli said some time back, whether a workman can go or the employee. This order dated 29th March, what we read here is talks about worker and employee under Shop and Establishment Act. So the definition of employee under Shop and Establishment Act does not differentiate between worker and manager. So even a general manager of a company can go under Shop and Establishment Act. So apart from litigation, which is there before the labor court, there are likely to be a dispute, many dispute before the authority under Shop and Establishment Act.
Yes, that's what I said in the beginning.
Yes,
also,
my
that
lord. Yes.
circular also doesn't say.
Yes, my lord. Thank you very much. Thank you.
Right.
So, is there?
Amir,
Sorry,
Amir,
please go ahead. Mr. Bhatia, do you
Can
want
you
to
ask
ask?
Mr. Sanjay Bhatia to ask?
yeah.
Please go ahead. Please go ahead.
I have, thank you very much for giving me the opportunity. I think what ESI, what you mentioned, Amir, is would definitely help, but only for those employees or workers who are covered in ESI. But those who are not covered in ESI would still be out of it, and there would be issue on that. So one is that how that one has to really handle. That is one. Second is the Justice Palli mentioned about the contract workers or contract where the contract is finished, but where the contract period is not there. I mean, when there is a season, you employ people, but when there is off season, you just don't employ them. So there would be, I mean, various cases like that. So maybe then we just employed before the lockdown because the season was starting, but now the season is also gone. Actually, the season with this lockdown, the season is also not there. I mean, in the employees, I would just say there are three categories. One, which is working. Second, which is sitting at home but willing to work. and third, which don't, I mean, they are not willing to work at all. I think there are various categories of employees also. So maybe you can give some view on that. Thank you.
Yes, Justice Rao.
Yeah. Now, yes, Mr. Bhatia, can you repeat what was the first question? What did you ask?
That's somebody's phone. It's not a hacker. That's the
Yeah,
good news.
Mr. Bhatt.
Mr. Bhatia, I think they didn't hear you. Could you say that again, please? Mr.
Yes.
Bhatia?
No,
yes,
I was
silent.
not able to unmute. Yeah.
Now,
No,
yeah,
first question.
Yeah,
First
Mr.
question
Bhatia.
was. First question was, sir, on the thing that the ESI, what Amir said, would give a relief to only those people who are covered in ESI. But certainly, what about there are various categories of employees who are not in ESI. So those situation would also be still be there. That was my first question.
Very right. Now, insofar as ESI is concerned, the liability of the employee is clearly under the ESI Act. So we are not concerned with those employees. Now, how is this affecting? How are those people who are not covered under the ESI Act? How is it troubling an employer?
No. Whether we have to pay them fully without work.
Insofar the wages are concerned.
Yeah.
Insofar the wages are concerned. See, look here, let's be very clear. If there is an appointment letter given saying that your appointment letter is for 3 months, 4 months, 5 months, 6 months, after the effects of time, that appointment comes to an end. If there is any kind of an appointment without an appointment letter, for all purposes, he is your worker. Unless you follow the rigors of 25F of the Industrial Disputes Act and terminate him or retrench him. If you have not done it, the liability will continue qua you. He will continue to be your employees. You will continue to have the liability of paying the wages to him. See, that's the position of law. If you had given any appointment letter, it would be regulated by the appointment letter.
Okay.
That's the position.
Can I pitch in here for a second?
Yeah.
See, Mr. Bhatia, there's another thing. Your problem is that you are having, now you are facing a problem where people who are not covered by ESIC, you still have to share the burden. As ESIC is taken away your burden for those who are covered. See, there in such cases, maybe you can sit with them, talk to them. As I said, the industry has to evolve its ways. It just can't be that because ESIC is not supporting. When we started this meeting, we were dealing with situation where other countries, the wages were being subsidized. Now, at least before we are ending, we have at least one order subsidized. So let's say it's been a fruitful meeting at least.
Okay.
And your second question was about the seasonal daily wages. That Justice Rao has answered. Whenever you have taken them in, they are in the lockdown period. So they can't be terminated for whatever be. Tomorrow, if it extends, God forbids, then maybe the government will come up with more orders and see how the situation is. I'm sure the government is cognizant of the problems of the employers also. So you will have to wait and watch. Until then, bear that you have to pay.
No, it cannot.
You've got a very simple, straightforward bench. The good news about this bench is that they don't bowl googlies.
Yeah,
There are no googlies here.
Mr. Chawla wants to come in.
Because this was a question
Mr.
which came
Chawla,
from
go ahead.
Advocate.
Apart from ESIC, which today said at 2:30 or 3 o'clock when the circular was out that they would bear 70% of the average daily wage of a person who is covered under ESIC. Now, the same circular which is issued by the PF department, which says that any establishment employing 100 or more persons and 90% of those persons are covered under PF, they would take care of those PF expenses also.
That was Finance Ministry.
That was Finance Ministry.
Finance Ministry.
And so far as this working hours are concerned, the government of Gujarat has issued a circular saying that now instead of working 8 hours, the employer can take work for 12 hours. and he is not required to pay overtime. He has to pay only single rate of wages.
Standard wages.
Earlier he was paying for 8 hours. Now he has to pay for 12 hours. If somebody was paying
At the same rate, pro rata.
100 rupees for 8 hours, now he has to pay for 140 for 12 hours of work.
See, Mr. Chawla, the government is looking into your grievances also.
Yes.
It's not like that it's not looking into it.
Yes, yes.
Looking into it. It's
That's
concerned with the employer also.
Mr. Mahajan wants to ask a question.
Dynamic situation, everything.
Sorry, not clear, Ladyship. Could you speak again?
I didn't say anything.
Oh, sorry. We missed something. Okay, we had one participant had asked a question, and then I'm going to take one more question. Mr. Ajay Mahajan, would you like to ask?
You have to unmute him.
Yes, I've done it.
What is the situation in which, if the state government says that the order given by the central government is ultra wires? I'm particularly talking about Punjab, wherein the chief minister has given a statement, and even the principal secretary has given a statement that it is only an advisory, and the order given by the central government, it is ultra wires, its authority, and they are going to challenge it. And they have advised the industries that they are not asking them to pay the full wages. It is, and they can take their own call. So what does the legality of a state government saying that they have not, like in the UP government has further passed on an order based on the 29th March notification, whereas the government of Punjab has clearly said that it is an advisory, and we have returned the file to the central government saying that it is ultra wise their authority, and we do not take cognizance of the order so far.
I think that issue will be decided by the Supreme Court in the next few days. I don't think we need to burden these judges with the same question, because maybe earlier in the session, they said that these questions are matters for the lawyers to take up in the courts. You'll see a specific decision and don't forget, it also depends on who's the litigant and what is his grievance. So you might have, in some cases, an order passed which is specific for that industry. You might have a challenge which succeeds and destroys the whole basis of that notification to that extent. I think the Supreme Court is going to answer this, or at least look at it quite seriously in the next 2-3 days. I'm going to ask one last question before we close for the session. And that is, I might have missed it, Your Lordship, but are your Lordship saying that in a contractual situation where I have signed a contract with a contractor, which contract says I can terminate with, let's say, 1 week's notice or 2 weeks notice, or it's a fixed term contract with the contractor, not with the laborer. And that contract is purely between me, that is the principal employer, if you want to call me that, and the outsourcer who might have, multiple employment contracts with call center people, guards, all sorts of employees of his. And the reason why I say this is this affects the industry also, the IT industry, where, for example, you have master service agreements which relate to and largely relate to hourly calculations. So the payments are all calculated hourly. There is no connect between the principal employer and the workman on the other side. So is your Lordship's the situation you described mean I have to carry on paying, or do we just follow that contract and respect that contract, treating it separately?
Shall I answer it?
Yes, Lordship.
Mr. Pashrij, you have to understand what is the arrangement. There is a principal contractor who has an agreement with the contractor, who in turn engages these people. That's right. That's the position.
Yes.
Yes.
Now, as long as this contract and this contract worker has his relationship with the contractor has come about because of this relationship with the principal employer. Now, to have an effect on the ultimate contract labor, this agreement has to be terminated between the principal employer and the contractor. As long as this agreement subsists on the basis of which the contract worker has been appointed, he can't be terminated. But I am giving even otherwise. Let's assume the principal contractor terminates the contract with the contractor. But still the contractor, while terminating the services of the contract labor, he has to follow the rigors of law. He can't escape the rigors of law. He has to follow it. But as long as this main agreement is continuing, how can you terminate the services of a contract labor? You can't.
I'm on the assumption that the main agreement is not continuing.
Is not continuing. Very well. Then the contractor need to follow the provisions of law while terminating the employment of the contract labor.
So during the MHA order, he has to carry on paying. That's that's the subtext of my question.
See,
During these programs.
Insofar as the relationship exists as an employer-employee, you need to pay.
And Mr. Pasrit, before we conclude on that part, it will ultimately again depend on the facts of each case. It can't be, that's what I said, both of them may be responsible. The contractor is definitely responsible. You may have a point that your agreement, suppose it expired in March itself, or on maybe 31st of March. That's what your question probably was.
Possibly. Yes.
That's what. Now, if it expires and you are not taking any work hours from there, anything, why you should pay? That question will ultimately depend on the intricacies of your agreement, and courts will decide ultimately. The contractor who had actually taken those people to work for you can't escape his liability. You may still, we don't know. I don't want to comment on that today because it will be decided ultimately in court. That's
I'll add on one more, Mr. Pasrit. I'll add on one more. I'm sorry to enter. This contractor has many agreements, has many contracts with other employers, right?
Yes.
Now there is a principle of last come, first go.
Yes.
Now when the principle of last come, first go it would be seen qua the contractor. Let's assume a person who has come later than A. Let's assume A has been appointed earlier and the B has come later. Now, while terminating, you will not dispense with A's contract. You will dispense with B, even though he has been engaged under a different contractor. But he must follow last come, first go principle, insofar as that contractor is concerned. See, that's the position of law. Under one employer, if there are 100 people are working under different contracts, you will follow the principle of last come, first go qua these 100 employees. That's another facet of it. See, this is very, the principles under 25F are this. You have to follow the rigors of 25F. You have to follow the rigors of last come, first go. Because he is employer for all 100 people.
I think
common employer.
That's very kind and helpful, and it's also appreciated. Some of these I will debate in your lordship's courts, and I will thank you for this wonderful.
Surely before Justice Pali.
Why?
No, not now.
Not now.
Before I ask for the vote of thanks from Mr. Sanjay Agarwal, who is our Senior Vice President of the PhD Chamber, I would personally like to thank you very much. I was extremely enlightened. I think I've learned a lot in these and we've got a 1.5 hour session, which was very kind of your lordships to give us so much time. I think we all learned a lot. If all of you who we can see on the videos can wave and say that you learned a lot.
Yes, absolutely.
It's a two-way process, Mr. Pasrit.
I would
it's always a two-way process.
Thank you so much.
It was very enlightening and very enriching.
Thank you.
Absolutely.
I'm going to ask the chamber to pick up, and for Mr. Sanjay Agarwal, I can't see him, but he's somewhere on the screen. To please.
I hope you can hear me now. Yeah?
Sir, we have Mr.
No, I'm unmuted, no problem. I'm unmuted, Rasibullah.
Mr. Khetan is asking a question, sir.
Sure, go ahead, Mr. Khetan. One second. I'm so sorry, Lordship. One last question. Suman
He's our former president.
Yes. Suman, please go ahead.
PhD chamber.
Suman, I can't see you, but you must be somewhere there.
Just unmute him also.
Just a minute. Just a minute. I have to find him. Um,
Done, sir, done. Yeah, Mr. Ketan, please go ahead, sir.
Thank
You are
you.
unmuted.
I think my chat has been blocked. Its chat is not going.
No,
No,
go
it's
ahead.
going.
Go ahead.
Now
We
you
can
can.
hear you.
Anyway, we can hear you.
Okay, I'm sorry I joined in late. But to say what it appears is there's too much uncertainty for the overall good of the country. And I appreciate your lordship's dilemma, because if your lordships were to express a view now, and if somebody, and I'm sure there's be a flood of litigation, then there may be some kind of a dilemma. But one thing is very clear, that the government's handling and this terms of the notification under the Disaster Management Act is actually not very well properly advised, because they have just given a blanket order that you pay 100% of the wages, which is not good for anybody. So I would, of course, since the virus has been challenged in Supreme Court, but somewhere we have to draw the line and we have to find a balance. So what I'm really suggesting is not really an appropriate or final legal answer today, but we have to also ensure that the industries don't close down, and there has to be an incentive for the workers to come back. You can't have a situation where they get fully paid without coming back. I mean, it's more of a comment rather than a question. Thank you.
No, I think it's a very valid comment, Suman. Thank you so much. And I think it's on uppermost in all our minds as
Yes,
to how
Mr.
we're going to
Pasrish,
fund
I
this.
would like to
Sorry.
sorry for interrupting. Yeah, I would like to
please
assure
go ahead.
Mr. Kritan that he should feel satisfied that the court will address this question very balancedly. Don't worry. We are not going on that. We are not commenting on the notice delicate situation. We all live in places where we all understand all this. So this delicate situation will be balanced by the courts ultimately. So that's, I only wanted to assure him.
Thank you. Thank you very much.
Thank you. And I'm glad, we hope the disaster management notifications don't turn into disasters themselves. With that, we move on to Mr. Sanjay Agarwal, our Senior Vice President, to please give us the vote of thanks. I'll also want to thank Mr. Peter Bartlett, who stayed on. This is not directly relevant to him, but he's been very kind to keep on with the session from Melbourne. It's now, I think, 10:30 at night over there. Thank you. Sanjay, please go ahead.
Thank you, Mr. Pasrich. It's really a great honor, sir, to be delivering the vote of thanks to your lordships, Justice Rao and Justice Pali. It's been very enlightening for us, and let me say it's been very auspicious for the industry today that right during the session, a huge relief in form of ESI accepting its responsibility, which we had rather been, rather anxious about, has come through. So I think that by itself is a great relief. From the other part is that you have been both very forthright, despite all the limitations you have, in the sense that you cannot really share your final opinions on anything which you suspect might come before you in the court. But despite that, I think the forthright manner in which a lot of our queries have been answered, I think the basic takeaway from this meeting is that the courts are not just going to, take a very hardened view or a very legalistic view, but rather a balanced view in terms of the circumstances, probably, which are going to be, which we are going to be facing in each individual matter. So I think that should also be a matter of satisfaction, because the notifications themselves seem to be very harsh. And just a plain reading of those notifications and the prosecution provisions actually do scare the daylights out of us. So I think yes, it's been a bit of reassurance to us that we will have the recourse to the courts where somebody is treating us unfairly. And let me assure your lordships that the trade and business is there to remain open. No trade and business, no enterprise is going to run without our employees. Nobody has the intention not to pay the employees. The intention is for the business to survive and for the employees to keep being employed. That is the intention, your lordships, and I think that is the intention of everybody here, I believe. So with this, I would like to thank Justice Rao and Justice Pali, as also all the dignitaries who have attended us, including our former presidents, three of whom I can see. and our president, Mr. D.K. Agarwal, and especially you, Mr. Pasrich. Thank you, everybody. It's been a great session, and we hope to do more of these. Thank you so much. Thank you.
Thank you.
Thank you very much,
Thank
Mr.
you very
Satyagraha, our Senior Vice President.
Thank you, Mr. Pashrich. Everyone, thank you,
Thank
Palli.
you. Thank you.